Consumer Counterpoint. I'm Christine Argentine, partner in our Chicago office at Cypher Shaw.
And I'm Paul Yovanik, a partner in the Chicago office as well.
And so today we're talking about a statute that has gotten some recent attention out in Washington.
Yeah, so today we're going to talk about the Washington Commercial Electronic Mail Act. It's a statute that was enacted in 1998. Didn't see a lot of activity up until recently, and then since 2025 we've seen well over 25, 30 cases, class action cases. And what this statute really is designed to do is and what we're seeing a lot of the allegations is prohibiting the subject line of emails with these false and misleading subject lines.
Yeah. I mean, and it's interesting, right? Because obviously email's been around for a long time. Marketing emails has been a really important function for our clients and retailers across the board.
Right.
And we've always, there's always been statutes out there, but CAN-SPAM, being the federal statute without a private right of action, has always kind of led the way of, yes, you need to worry about this, you need to follow CAN-SPAM, but because there's no private right of action, we weren't obviously seeing class actions in the space.
Right. And so, and with CAN-SPAM, there has been this carve out for any of this, deceptive type of communication. And that's really kind of where this statute and other state statutes, with this deceptive trade practice, is really kind of fitting and filling into that exception, which is, something that's been really subject to the litigation over the last few years. We've got a lot of defendants that have been arguing that, this Washington statute is preempted by CAN-SPAM, and there's been a lot of decisions, even up until recently, saying, well, no, it's not.
Right.
We've also seen the Washington Supreme Court give a little bit more guidance on, what is essentially puffery in these communications and these subject lines compared to what is, actually deceptive.
Right. And let's talk about that a little bit, right? Because we see puffery a lot in a lot of consumer cases, right? The difference between what is actionable and what is puffery. Puffery being, a statement that doesn't have a lot of teeth.
Right.
And that, is a more generic statement about the brand or about the product, but that isn't necessarily deceptive. So talk a little bit about what the Washington court kind of looked at in that regard.
Yeah. So when the Washington Supreme Court kind of gave some guidance on that, they said, courts will consider, as puffery, maybe in a subject line, best deal of the year. At the time, it's probably the best deal of the year. But it doesn't mean that if there is a better deal 3 months later in the year, that all of a sudden now that was deceptive. It's just at the time.
Right.
Because, the court was saying that we can't really look at, what the market and what the future will hold. But if you're going to say best deal of the year at the time, that is it's almost a harmless, if it is in fact, the best deal of the year.
Right.
What we're seeing, I think really the difference is, these email subject lines saying, limited time, and that time never really expires. The price stays the same after that limited time, or, inflated discount. So you're jacking up the price and then saying, 40% off. That is misleading, because then you see, oh no, that price was never that high, or free offer, and then you realize you're paying for something more for something to get that free item.
Right.
Those are what we're seeing in the lawsuits as of lately.
Yeah. I mean, and there's substance to those, right? Like you said, best deal of the year arguably could be right at that moment in time.
Right.
Whereas, a free item that isn't really free because you've got to purchase something else.
Exactly.
Is provable, right? There, you can put evidence behind that to say this was deceiving.
Yeah.
Right.
I clicked on this email expecting to get something for free. Turns out I had to spend $100 to get it. That's or this product that's normally $50 is now $70, but you're telling me I get something free. I'm not getting it free.
Right.
I'm paying $20 more for that, or I'm paying $100 to get the free item. That's not what it was designed to do. Again, something like best deal of the year or amazing deal, harmless.
Yeah.
It's an amazing deal, but it's doesn't. You're not telling someone, hurry up and react now to this amazing opportunity because you'll never get this opportunity again. When in fact you can.
Right. So the Washington statute then, right, of course you said we've seen a lot of new cases being filed, new class actions being filed in Washington. The statute itself is limited to Washington residents.
Right, but we've been seeing some fights over, whether or not it is actually a constitutional statute. There's really kind of been, two fights. One, the Dormant Commerce Clause. Okay. And so they've been kind of really arguing that, this statute regulates beyond the state of Washington, and we have businesses outside of Washington, and how does that impact them? And so there's kind of this other argument of it's really burdening interstate commerce excessively in relation to the local benefits.
Okay.
The other part was the challenge that we were seeing was federal preemption of canned spam. But as we discussed, there is this specific carve out for this deceptive practice in canned spam, and that really seems to be where the Washington statute says, hey, we're filling that right there. Yeah. We're saying that there's this carve out here, and if your conduct falls within this carve out, we have this statute here.
Right. And honestly, we do see, many states have email statutes that are similar to canned spam, right? Sure. And so what the canned spam preemption provision says is that if your state statute goes beyond, right, the purview of canned spam and covers deceptive trade practices, that's where a state could provide a private right of action.
Exactly.
Under that statute.
Right. And so even as of recently in March, we had a federal court that did actually provide a ruling that this Washington CEMA statute is neither unconstitutional nor preempted by canned spam. Okay. And really, there's been cases that have already touched on that, and this just kind of reaffirmed some of those positions. And the court said CMA neither improperly discriminates in favor of in-state interests nor improperly controls commerce occurring wholly outside the state. And so really, it is focused to protect Washington residents, but I think it says it does that first and foremost, such that there is no violation of the Dormant Commerce Clause. Now whether we see some sort of challenge go up to the U.S. Supreme Court on a challenge of constitutionality, we'll see, and we'll see what that analysis looks like. But for now, we have defendants businesses looking at these cases, and based on the way that they frame their subject lines of their emails, they're going to be in it right now.
Right. And the practicality is that any national business that is sending marketing emails, right, aren't doing it on a state-by-state basis.
Exactly.
Right? They're sending it to their database of emails of people that have said they're interested in or purchased a product or however they got that email address, and that's going to include Washington residents.
Exactly. And so originally, this statute had violations of $500 per violation, and so that was the statutory penalty for that. Starting in February and into March now, the House and Senate in Washington approved by an overwhelming majority to modify or amend that statute, removing the $500 per violation down to $100. And I'm assuming, and likely in response to what we're seeing is this large number of lawsuits, but also, as you mentioned earlier, we are now seeing emails at a higher volume than we would have in 1998 when this statute was enacted. So where in 1998 maybe there was this envision that, okay, emails go out, and we didn't have this auto email systems. We didn't have these type of advanced marketing tools that we have now. The damages can't be that high, but now, as you said, we have thousands, tens of thousands, hundreds of thousands of subscribers for some companies getting emails, and now all of a sudden that's the size of a class potentially.
Right, and that's it's going from 500 per violation to, I assume, 100 per violation.
Exactly.
Right, which of course is good for the businesses, for the defense, but still can add up very quickly.
Still significant when you're looking at tens of thousands or 100,000 plus, and so it's still not something where businesses should say, okay, never mind, they just reduced it from 500 to 100, we're okay. It's still significant.
Right.
The other change that they made to the statute was in the section talking about there's this language that says that the message originally it says contains false or misleading information in the subject line. That's all it really said. And that's specifically all it said. They had now amended it to say that it uses a subject line in which, based on the person's actual knowledge or knowledge fairly implied on the basis of objective circumstances, contains false or misleading information in the subject line. And so this, based on the person's actual knowledge or knowledge fairly implied on the basis of the objective circumstances, that looks like it could be a little bit more difficult on a motion to dismiss.
Yeah, but it also feels like it could be a little bit more difficult on a class cert.
Yes, that is 100%.
Sounds like an individualized issue to me. Now, of course, the second part of that feels like the reasonable consumer standard a little bit. If you can objectively say, right, that this is how people would observe this, but...
Right, but I would be surprised to see a federal judge make a determination at a motion to dismiss unless it was just so blatant that, like, him and a reasonable expectation that, like, that does not violate CEMA.
Right.
But, as you said, we're going back to this actual knowledge or knowledge fairly implied based on the objective circumstances. How do you get to that? How is someone similarly situated and adequate to represent a class that we don't know what each class member was thinking
or saw before that would kind of lead to certain knowledge when they see the email. Now, is this amendment in effect, or is this proposed?
It's already approved by the House and the Senate, overwhelming majority, waiting for the governor's signature. So, and I would say based on, so the House passed it 86-11, the Senate 43-5. Like, even if there was a veto, they have the power to override. So I think I would expect this to be good.
Okay.
And so...
Any retroactive language in here?
No, there's no retroactive language. Obviously, that's something we've dealt with other privacy statutes of whether it's retroactive, whether it was intended to change, modify. So we'll probably see those fights.
Yeah.
Based on what the legislative intent was, what it was in response to.
Yeah.
So we'll have to see. So we're sitting here there. But, you make a great point, though. We always talk about, well, maybe it's going to be a little bit more difficult at a motion to dismiss. What that means is you'll probably be in it for a little bit longer.
Yeah.
But you get to class certification, you start trying to make these arguments here. I mean, it is that second shot to say, and I think the plaintiff's bar needs to be aware of that too. I mean, there are businesses that are not going to lay down.
Right.
They might be into it beyond the motion to dismiss into discovery.
Right.
You're going to spend the time and money on a case that could end up blowing up at class certification on these types of issues.
Yeah. But, we often see a business analysis being done in these types of cases too, right? Because this marketing is very important to the businesses. And so there's often an analysis done in terms of, how exactly are we going to put this language together and what amount of purchases are we getting off of these emails that are going out? Now, of course, right, deceptive trade practices, deceptive language extends beyond email statutes, right? Every state's got its own deceptive trade practices statutes. So businesses really need to be mindful about exactly how they're presenting that language and whether or not they can defend the truthfulness of what is being stated.
Right. And I think, and this is something we've discussed previously, we have a statute like this that will, make it actionable potentially for misleading, limited time only sales or, ends in 12 hours and then it still sticks around. But there are other claims that can be tacked on as, well, it might not violate this, but it could violate other deceptive, practices claims that can be made. And so it's not just to say this is the only time you have to worry about that. There are other potential exposures out there that can play off of this very type of conduct that the plaintiffs are alleging here in this Washington statute.
Right. And I think it's probably worth noting that Washington's not the only one with a statute, right? California has an anti-spam statute. A lot of states have anti-spam statutes, and a lot of them have specific provisions related to deceptive statements in the subject line, in the body of the email. So, and whether or not all of them provide a private right of action, California's does, but others don't. But businesses really need to be mindful about all of their marketing, right?
All their marketing, all of their messaging, what they're doing. I mean, we even see it, for example, in Illinois, with there's certain laws against like how the mailing has to look when they send something out in the through the post office. If it is in fact an advertisement, this is not a bill or any type of collection, because they just want to make sure that when you're reading this, you're going into it with the mindset of, oh, you're offering something for me to purchase. This is not some sort of other type of mailing. So I mean, we just see there's been a lot, especially in the last few years, just a lot of focus on making sure that consumers are, I think, mentally in the space that they need to be in when they're looking at these emails. When what are they expecting when they open up this email, when they open up this letter, when they open this up?
Right. It's all about transparency these days.
It is. It really is.
Yeah.
I guess we'll keep updated on what happens following this amendment, and any later decisions or challenges on constitutionality.
Absolutely.